Mediation Bill 2021. Source: The Hindu. Context: the Mediation Bill 2021 was introduced in the Rajya Sabha with the Parliamentary Standing Committee being tasked with a review of the bill. Parliamentary Committee recommendations on the bill: institutionalizing mediation, establishing the Mediation Council of India. Laws containing mediation provisions. Code of Civil Procedure, 1908, Arbitration and Conciliation Act, 1996, Companies Act, 2013, Commercial Courts Act, 2015, Consumer Protection Act, 2019. Need for mediation. Mediation and Conciliation Project Committee of the Supreme Court of India. It describes mediation as a tried and tested alternative for conflict resolution. India as a signatory to the Singapore Convention on Mediation, it is appropriate to enact a law governing domestic and international mediation. Lowering the burden of the judiciary. Over 3 crore cases are pending in regular courts. Aim of the bill: to promote, encourage, and facilitate mediation, especially institutional mediation. To resolve disputes, commercial and otherwise. Key features of the bill: mandatory mediation, before litigation. Rights of litigants. It safeguards the rights of litigants to approach competent adjudicatory forums, courts for urgent relief. Mediation Settlement Agreement (MSA). It will be legally enforceable and can be registered with the state, district, taluk legal authorities within 90 days. Mediation Council of India. The bill establishes the Mediation Council of India and also provides for community mediation. 12 or Insights on India. Concerns with the bill. Pre-litigation mediation is mandatory for both parties before filing any suit or proceeding in a court, whether or not there is a mediation agreement between them. However, this may lead to denial of justice. Mediation should just be voluntary, and making it otherwise would amount to the denial of justice. Clause 26. It gives power to the Supreme Court or the High Court to make laws of pre-litigation according to them. Is unconstitutional. The committee objected to this clause. Conducting cross-border mediation in India, it will exclude the tremendous benefits of worldwide enforceability. Non-applicability to non-commercial disputes. The parliamentary members questioned the non-applicability of the provisions of the bill to disputes matters of non-commercial nature involving the government and its agencies. Conclusion. In order to enable a faster resolution of disputes, the bill should be implemented after discussion with stakeholders. Insta-links, a bill that could alter the mediation landscape. Mains links, Q. Critically analyze the provisions of the Mediation Bill 2021. The criterion for SC status. Context: the government has set up a 3-member commission headed by former CJIK G. Balakrishnan to study the possibility of according SC status to Dalits who have converted to religions other than Buddhism and Sikhism. The law in the present form. The Constitution Scheduled Castes Order 1950 provides that only those belonging to Hindu, Sikh and Buddhist communities can be categorized as SCS. Originally it was limited to only Hindus. However, subsequent amendments in 1956 and 1990 included Sikhs and Buddhists respectively. Government stand. Union government in 2019 rejected the possibility of including Dalit Christians as members of SCS. Imperial Order of 1936, classified a list of the depressed classes and specifically excluded Indian Christians from it. Why are Dalit Christians excluded? The practice of untouchability. It was a feature of the Hindu religion and its branches, not Islam or Christianity. The Registrar General of India. It had cautioned the government that SC status is meant for communities suffering from social disabilities arising out of the practice of untouchability. A mandate in Rules for Inclusion. It was framed in 1999 and requires RGI approval. An amendment to include Buddhist converts as SCS was passed in 1990. Clause 2 of Article 341 for inclusion. Dalits who converted to Islam or Christianity belong to different caste groups, as a result of which they cannot be categorized as a single ethnic group required for inclusion. Case for inclusion. Several independent commission reports have documented the existence of caste and caste inequalities among Indian Christians and Indian Muslims. Casteism. Even in Sikhism and Buddhism, casteism is not present and yet they have been included as SCS. Advocate representing Dalit Christian bodies. Empirical evidence did not exist for including Sikh or Buddhist converts either and yet they were included as SCS. Registrar General of India. Established in 1949 under the Ministry of Home Affairs. To develop a systematic collection of statistics on the size of the population, its growth, etc. Later, this office was also entrusted with the responsibility of implementing of Registration of Births and Deaths Act of 1969 in the country. It arranges, conducts and analyzes the results of the demographic surveys of India including the Census of India and Linguistic Survey of India. Insta-links, Scheduled Caste National Commission for Scheduled Castes. Mains links, Q. Whether the National Commission for Scheduled Castes NCSC can enforce the implementation of constitutional reservation for the scheduled castes in religious minority institutions. Examine UPSC 2018 Prelims links Q. With reference to National Commission for Scheduled Castes NCSC consider the following statements. A. It is a statutory body that works to safeguard the interests of the scheduled castes SC in India. Though the Commission has powers to set up special courts for the speedy trial of offences under the Civil Rights Act. Which of the statements given above are correct? A. 1 only, B. 2 only, C. Both 1 and 2, D. Neither 1 nor 2 ones, B. Or. Insights on India. Com 13. Parliamentary committees, their leaders and their role in context. Recently, 22 standing committees were reorganized. Parliamentary Standing Committees are permanent committees. It is constituted every year and work continuously as against non-permanent ad hoc committees. The necessity of Parliamentary Standing Committees PSC for upholding government accountability. Increased volume of work, time constraints, disruptive changes, and complexity of work make Parliament not very effective in upholding the accountability of the executive. PSC through detailed scrutiny increases the Parliament's ability to scrutinize government policies and help in the informed debate in the legislature. e.g. Personal Data Protection Bill was sent to the Joint Parliamentary Committee for detailed review. For upholding fiscal prudence, PSC examines budgetary allocations for various departments and other policies of the government. It ensures fiscal economy and efficiency in public expenditure. Parliamentary Standing Committee on Defense last year pointed out that over 35% lower allocation on defense may impair the armed forces' weapon acquisition plans. For free and nonpartisan debate, PSC provides the platform for closed-door meetings and members are not bound by party whips, thus allowing them the latitude for a more meaningful exchange of views. For protecting citizens' rights, e.g., the Parliamentary Standing Committee on Information Technology grilled two Twitter India representatives this year, 2021, over concerns about safeguarding people's rights on the social media platform. For all around engagement with relevant stakeholders, e.g., on the subject of demonetization, the RBI governor was summoned by the Finance Committee. E.g. on net neutrality and surrogacy bill, the Standing Committee conducted a widespread discussion with several stakeholders. For acting as the link between Parliament and the people and between administration and the Parliament, PSC seeks public feedback to make laws more holistic and far-sighted. PSC acts as mini Parliament. The members represent smaller units of MPs from both houses, and across political parties. They are not bound by populist demand, remain informal and work away from public and media glare. Thus they are better suited for providing holistic and non-biased advice and scrutiny of the bills. Measures to reform PSC functioning. Committee referrals. It should be made mandatory for all the bills and budgets to be examined by PSC by convention. For this, rules of procedure in both Lok Sabha and Rajya Sabha be amended. Increase the tenure. Some constitutional experts argue to increase the PSC tenure from 1 year to 2 years, to give them more time and gain more expertise in their respective areas. Expert support for committees. Institutional research and expert support will allow committees to better scrutinize the bills and recommend innovative solutions to the government. Mandatory discussion of all major reports. Major committee reports should be discussed in Parliament as for the reports where there is a disagreement between a committee and the government. NCRWC recommended periodic review of PSC. The RSCS should be periodically reviewed on their utility. Recommendation of former President Pranab Mukherjee. Parliamentary standing committees should scrutinize ministries that are not audited by PAC. Conclusion. Thus, strengthening the committee system and bringing changes in the passage of bills will ensure greater quality of legislative work and minimize potential implementation challenges. Also, concerned ministers should be made to appear before the committee to explain and defend the government policies, as is done in other countries. This will help in ensuring representativeness, responsiveness, and accountability in the parliamentary working. Insta Links Parliamentary Standing Committee. Mains link. What are parliamentary standing committees? Why are they necessary? Discuss their roles and functions to bring out their significance. Prelims link. Q. With reference to the Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the powers to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the Executive within the scope of such delegation. 2018 A Committee on Government Assurances. B Committee on Subordinate Legislation. 14 Insights on India. Com. C Rules Committee. D Business Advisory Committee. Answer B. Judiciary. Issues and recent reforms in the Supreme Court. Chief Justice of India, CJI, has written to the government recommending his successor in the post. As per the convention of seniority, Justice D.Y. Chandrachud will take over as the next CJI. However, it will have an unusual collegium. Instead of 5 members, it will have 6. What is a 5-juror collegium? Apart from CJI, there are 4 senior most judges in the collegium system. Normally, the next CJI is among these 4 judges. However, this time, since Justice Chandrachud's tenure is for 2 years, the next potential CJI is not among the 4 senior most judges. Therefore, to accommodate the next CJI in the collegium, the collegium is expanded to 5-juror collegium system. It is the system of appointment and transfer of judges that has evolved through judgments of the SC. The SC Collegium. It is headed by the CJI and comprises 4 other senior most judges of the court. HC Collegium. It is led by its Chief Justice and 2 other senior most judges of the court. Ordinarily case, one of the 4 senior most queen judges of the Supreme Court would succeed the Chief Justice of India. Situational. If the situation is such that the successor Chief Justice is not one of the 4 senior most queen judges, he must invariably be made part of the collegium. Background of Collegium System. First Judges Case 1981, it declared that the primacy of the Chief Justice of India (CJI's) recommendation on judicial appointments and transfers can be refused for logical reasons. The ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. Second Judges Case 1993, SC introduced the collegium system, holding that consultation really meant concurrence. It was not the CJI's individual opinion, consultation with the 2 senior most judges in the SC. Third Judges Case 1998, SC on President's reference expanded the collegium to a 5-member body, comprising the CJI and 4 of his senior most colleagues. Issues with the collegium system. Extra-constitutional or non-constitutional body. Brought in force by judgments of the Supreme Court. No seat for non-judge. There is no seat in the collegium for any non-judge, neither from the executive, the bar at sea. This violates the principle of checks and balances. Opaqueness, lack of transparency as meetings are held behind closed doors. Nepotism, scope for nepotism. Overlooks talent, overlooks several talented junior judges and advocates. Issues with judicial appointments. Biased collegium. Experts allege that successive collegiums not putting forth names disliked by the government. No one from distinguished jurist. There have been no appointments from the category of distinguished jurists under Article 124 Preserve of Judges. Appointments to the top court seem to be the preserve of judges from the high courts with a handful of appointments from the bar. Steps taken in recent years. Constitution benches. 5 constitution benches were formed. Administrative changes. Transparent and prompt listing of cases. All the judges get an opportunity to voice their opinion. Major decisions are taken now in the Supreme Court after 4 court meetings. Live streaming of Constitution bench hearings. However, there are a few concerns. Almost 60 to 70 cases are listed before every bench. It has raised questions about whether judges are able to cope with the work pressure. Sudden listing of cases. leads to less time for lawyers to prepare their briefs for their cases. Way forward, transparency. There is a need to revisit this and secure a better, broad based, and transparent method of appointing senior judges to the High Courts and the Supreme Court. Constitutional mandates of effective checks and balances must be adhered to ensure accountability even for the judiciary. Constitution Bench. It consists of at least 5 judges of the court who sit to decide any case involving a substantial question of law as to the interpretation of the Constitution of India or for the purpose of hearing any reference made by the President of India under Article 143. This provision has been mandated by Article 145(3) of the Constitution of India. Or Insights on India. Com 15. The Chief Justice of India has the power to constitute a constitution bench and refer cases to it. Insta links, CJI. Mains links, Q. Critically examine the Supreme Court's judgment on the National Judicial Appointments Commission Act, 2014, with reference to the appointment of judges of the higher judiciary in India. UPSC 2017. Prelims links, Q. Other than the fundamental rights, which of the following parts of the Constitution of India reflect the principles and provisions of the Universal Declaration of Human Rights 1918? UPSC 2021. Preamble 2. Directive Principles of State Policy 3. Fundamental duties. Select the correct answer using the code given below. A and 2 only, B 2 only, C 1 and 3 only, D 1, 2 and 3 ans, D. Decision by larger bench. Context. A constitution bench of the Supreme Court has unanimously held that a judgment delivered by a larger bench will prevail over the decision of a smaller bench, irrespective of the number of judges constituting the majority in the larger bench. Mechanism of functioning of benches. Positive implications of larger bench. Stability and consistency. It seeks to ensure that there is stability and consistency in the decisions of the court. Correct decisions. A bench with more strength is more likely to arrive at a correct decision. Issue with larger benches. A majority decision is treated as the ruling of the entire bench, ignoring the opinion of the dissenting judges that examined the question. If a larger bench arrived at a decision by a slim majority, say 4:3 in a 7-judge bench, its correctness can be doubted on the presumption that had the bench comprised different judges, the outcome might have been different. Consequences of a decision based on a number of judges rather than a bench. Every decision of a larger bench could be doubted and overruled on the ground of plurality of opinions, thereby toppling the certainty and stability of decisions. Correctness of a decision would become a game of numbers rather than reasons. Recommendation to avoid such conflicts. There should be a quorum with a break-even or a greater majority than the lower bench. For example, if a 5-judge unanimous decision is referred to a larger bench, it should be considered by a 9-judge bench rather than 7, so that it would, in any case, be decided by a majority of at least 5 judges. The doctrine of precedence. The doctrine refers to a decision that has already been taken by a higher court as binding to the lower court and at the same time stands as a precedent to the lower court judgment, which cannot be altered by a lower court. Article 141 stipulates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. Constitution Bench. It is the name given to the benches of the Supreme Court of India, which consist of at least 5 judges of the court who sit to decide any case involving a substantial question of law as to the interpretation of the Constitution of India for the purpose of hearing any reference made by the President of India under Article 143. This provision has been mandated by Article 145(3) of the Constitution of India. The Chief Justice of India has the power to constitute a constitution bench and refer cases to it. Insta links. Reforms brought by CJI Lalit in SC. Mains links Q. Critically examine the Supreme Court's judgment on the National Judicial Appointments Commission Act 2014 with reference to the appointment of judges of higher judiciary in India. UPSC 2017. Lok ADALATS. Context. Over 450 prisoners have walked free in Chhattisgarh after Lok 16 Insights on India. Com. Adalats were set up in jails across the state. About the initiative. Lok Adalats in jail will be held every working Saturday and provide relief to wounded trials, and in some cases convicted prisoners, by explaining their rights and legal options such as plea bargaining and settlement. It is a first of its kind initiative anywhere in India. It will help reduce jail congestion. There are over 20,000 prisoners lodged in various jails in Chhattisgarh, against a sanctioned capacity of 14,000. Lok Adalat, it means People's Court, and is based on Gandhian principles. It is one of the components of the Alternative Dispute Resolution ADR system and delivers informal, cheap and expeditious justice to the common people. The first Lok Adalat camp was organized in Gujarat in 1982 as a voluntary and conciliatory agency. It was given statutory status under the Legal Services Authorities Act, 1987. Function of Lok Adalat. Provide relief to under-trials and in some cases convicted prisoners, by explaining their rights and legal options such as plea bargaining and settlement. Objectives. Swift disposal of cases, reduce the congestion in various jails. Who is eligible? All under trials, named in offences in the Criminal Procedure Code (CR). PC heard by a judicial magistrate, such as petty theft, house trespass, and cheating, those arrested under preventive provisions, for offences such as raw law violation of special laws such as the Excise Act or Railways Act. How does Lok Adalats function? Article 39A. It provides that state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity. Insta links. Lok Adalat National Legal Services Authority NALSA. Mains links Q. What are the major changes brought in the Arbitration and Conciliation Act, 1996 through the recent ordinance promulgated by the President? How far will it improve India's dispute resolution mechanism? Discuss. UPSC 2015. Constitutional bodies. Electoral participation. Context. Election Commission had signed MUS with over 1,000 corporate houses undertaking to monitor the electoral participation of their workforce, and publish on their websites and notice boards those who do not vote. Cause of concern. These developments raise serious issues surrounding voters' rights, compulsory voting, the secrecy of voting, and debates around privacy and coercion. Probable reasons behind lower voting. Migrant workers are not registered as voters at their place of work out of conviction or for ideological reasons. Some people don't vote. More importantly, there are millions of daily wage workers, and many homeless and ill. How do the above developments violate the law of the land? Section 79D of the Representation of People Act, 1951 defines electoral right to mean the right of a person to vote or refrain from the vote at an election. The law completely enables but does not force citizens to vote. Section 135B of the Representation of People Act, 1951, grants a paid holiday to every person employed in any business, trade, industrial undertaking, or any other establishment. Employers at best can cut the wages of those who take leave but don't go to vote. Article 14. Protection of the elector's identity and affording secrecy is integral to free and fair elections, and an arbitrary distinction between a voter who casts and a voter who does not cast his vote is violative of Article 14. Supreme Court judgments. The Supreme Court, in PUCL vs Union of India, 2013, popularly known as the Nota O. Insights on India. Com 17. Judgment has held that abstention from voting and negative voting is protected as freedom of expression, a fundamental right, Article 19. How to enhance voter participation. Systematic voter education, amply demonstrated by the AC in elections in all the states and union territories since 2010, when a voter education division was set up. This soon evolved into its SVEP program. In the 2019 Lok Sabha election, the 67.3% turnout beat all previous records. Many states have reached close to 90% turnout and above. Motivation and facilitation, rather than compulsion, are the best ways to address the issue, which has been clearly vindicated by AC. Involving institutional participation, such schools and colleges take the registration facility to the doorstep by introducing voter clubs, campus ambassadors, and youth icons, and placing drop boxes in colleges for new applications. Employers have been encouraged to create similar facilities in their offices. Strictly enforcing the law. Employers are legally obliged to close their establishments on poll day, but this is seldom enforced. Instead, employers are asked to allow the employees a couple of hours off to enable them to go and vote. Mains links discuss the role of the Election Commission of India in light of the evolution of the Model Code of Conduct. UPSC Mains 2022. Government policies and interventions. The dismal case of slashing schemes and cutting funds.